name is Brent Pullman. I'm a partner in the Labor and Employment and Corporate Groups with Mandelbaum Barrett, and this is our June webinar for the New Jersey Restaurant and Hospitality Association's ongoing educational series. Today, we are going to talk about workplace investigations. In the hospitality industry, workplace investigations generally arise in the context of an allegation of wrongdoing by an employee, by maybe a customer, by a guest, by a vendor or a contractor who's working on site. Those allegations could be harassment, discrimination, physical violence, theft, destruction of property. As an employer in the state of New Jersey, we have an obligation to provide for a safe workplace for our employees. We also have an obligation to undertake investigations into allegations of impropriety, harassment, discrimination, retaliation, workplace violence, or theft. In order to ensure that we are satisfying our legal duty and conducting these investigations in a legal and effective manner, it's important to develop an investigation plan, documents, and to train our staff. We can't begin to think about the investigation when the complaint arises. We have to have a process and a procedure and policy that's ready to go from the moment we receive a complaint. So there are 9 elements of a workplace investigation. And we're going to go through all of those today. We're going to talk about how you can prepare ahead of time, what needs to be done at the time of the investigation, and what we do after the investigation. So the first element of a workplace investigation is maintaining confidentiality. Now, to a certain extent, confidentiality cannot be guaranteed. It may not apply to all individuals. And the reason is that, unfortunately, depending on what you learn, you may have to make disclosures. You may have to make disclosures to other employees. You may have to make disclosures to vendors or contractors, or you may have to make disclosures to law enforcement or a government agency. However, to the extent that we're not obligated to make any type of disclosure to a third party, we do want to ensure and let our employees know that we will maintain confidentiality to the extent possible. And there's a couple of reasons for that. The first is employees are going to be much more forthcoming and truthful if they believe that the information they're sharing will be kept confidential to the extent possible. If they have a concern that truthful statements they make about a supervisor, manager, or even a coworker could get back to that person, they may fear retaliation, they may fear a breakdown in their relationship, and so they're less likely to be fully transparent and honest with you. The second part is that when we're conducting an investigation, we want to make sure that people don't continue to discuss the subject matter of the issue. We want our employees to be told that, hey, we're not going to talk with your colleagues, with your coworkers about what you tell us, and we don't want you to continue to gossip or discuss this matter. One, it may contaminate the pool of witnesses, and somebody may say to a coworker, "Oh, I told management that I saw this and that happen," and that coworker then may internalize that and think to themselves, "Yeah, maybe I saw that happen as well," and it could taint their recollection. So we want to make sure that we advise our employees that not only are we as an employer going to maintain confidentiality, but we expect that they'll maintain that confidentiality and not disclose their statements to colleagues, coworkers, contractors, or guests. Now, of course, we want to caveat that with always, if an employee feels that they've been subject to any wrongdoing, their rights have been violated, a victim of a crime, they of course can report that to law enforcement or the appropriate government agency. And finally, we want confidentiality to protect our employees. If an employee's been a victim of workplace harassment, discrimination, retaliation, or violence, we don't want other people talking about that. We want the employee to feel safe at work. And an employee is certainly not going to feel safe if after they file a complaint, their coworkers, other staff members are aware of what they said and are gossiping and discussing it. That's actually one of the things that could cause an employee to feel that they're maybe being retaliated against and may result actually in litigation against the employer. And so the first thing we want to do when we receive a complaint and have to undertake an investigation is to take all steps necessary to ensure confidentiality. And that's by reminding all of these stakeholders, all of the witnesses, all the people we meet with, that we expect confidentiality maintained. And from the employer perspective, to do our part to protect the statements, to protect the evidence, and not have that available to the world at large and the employees at large. The second element of the investigative process is providing interim protection. This really only arises in instances of, workplace violence, bullying, and harassment. However, if you receive a complaint and the employee, the contractor, vendor, guest, resident expresses that they feel a concern of immediate harm, they feel that they may be in danger, we have to respect that. We have to evaluate the situation and make a determination as to what needs to be done to protect this employee, to protect our staff and the business while the investigation is being undertaken. Now, some appropriate courses of action may be to send one employee home, could be the accused. You may send the complaining employee or the victim, tell them that they can go home, but they'll be paid. And that, you want them to be able to go home, relax, compose themselves, and assure them that they're not being disciplined, but that the company will continue to pay them. But if they're uncomfortable or feel unsafe, we want them to not be in the workplace while this matter is being investigated and resolved. Certainly in issues of workplace violence, we will want to be calling law enforcement immediately. While we'll conduct an investigation into the employment practices portion of that complaint, if there was a instance of workplace violence or an allegation that is reasonably credible, you will want to contact law enforcement. As employers, we enforce employment policies. We're not responsible for enforcing the law. Next, our third prong is selecting the investigator. Now, before we even get to receiving the complaint, employers should identify who their investigators will be. Now, we recommend that it be somebody who has supervisory or managerial responsibility. That's the type of appropriate person in most businesses. You also may want to consider having a third-party investigator who's available when needed if the allegation involves supervisors, managers, or the top tier of upper management, meaning that there would not be anybody who would be available to conduct the investigation who may not be under the supervision of that person. Or, as you can imagine, it'd be very difficult for an employee to have to supervise an employee to have to investigate an individual who has supervisory or managerial authority over them, as the ability to set their hours, to evaluate their job performance, provide them with increases or decreases in compensation, approve their time off. So it is helpful to have a resource available when needed that can be an outside third-party investigator. Now, you can have your attorney do that. There certainly also are human resource support businesses and consultants who undertake investigations and provide those services. Once you've identified who your internal investigators will be, you want to ensure that they're appropriately trained. And there are, again, a number of services out there that do provide training to managerial and supervisory employees on the appropriate way to conduct an investigation, to role play it with them, give them examples of what to do. We highly recommend that, because you could be an excellent manager, you could be excellent in the subject matter of your business, you could be a very good leader, but unless you've had to undertake an investigation yourself, it can be overwhelming. You may not be prepared for it. So it is important that we ensure that the people who we are going to delegate or assign those responsibilities are appropriately trained to do so. Next is creating a plan. So an employee has come to you and made a complaint that needs to be investigated. You've assigned the investigator. So now your investigator needs to determine, do I have to provide any interim protection? They have to determine, what are the allegations? Who is going to be interviewed? Where will the interviews be done? Are there outside evidence or other evidence that needs to be evaluated, such as text messages, emails, security video recordings, social media posts. Those are all the decisions that need to be made going into the investigatory process so that you ensure that you're planning to undertake a thorough and complete investigation. Once you've created your investigatory plan, the fifth element is developing interview questions. So the most basics are as they say in the newspaper journalism business, the who, what, when, where, and how. You need to solicit and obtain from the individuals who you're interviewing who was involved in this altercation. And sometimes it may not be clear who was the aggressor, who was the victim. Somebody who was a complainant may in fact have been an aggressor at first. And so you don't want to go into that investigation with any type of predetermination as to who did what, who was responsible for what, and ultimately who the victim is and who the accused is. You want to go into it with an objective mind, and you begin by asking the witnesses, what did you see happen? Who was present? What did you personally observe? What communication statements did you hear individuals make? Many times when employees, whether not just the complainant or the accused, but even employees who are being brought in as witnesses are being interviewed for these types of matters, they can become nervous, they're upset. This is probably maybe the first time that they've ever been questioned as part of a workplace investigation. And they can be very excited. Certainly if it's a victim or it's an accused, they could be very nervous and upset. And so it's important to try to de-escalate that individual and to have them be calm. And so, the way you do that is by asking people specific questions, making sure, say, okay, where were you when this happened? And what time was it? Who else was present when this started? Did anyone else come? And when you ask basic questions, it gets people into a level of comfort where they calm down. It becomes more of a conversational exchange, as opposed to if they feel they're being interrogated. And then, once you've got them calm and you've asked the specific questions, you can allow them to open up and ask more open-ended questions and allow them to sort of give you their overview and opinion as to what happened, which may be important. You can glean some critical information. Other questions you want to ask: were you aware of there being any other workplace issues with these employees? Are you aware as whether or not there was a relationship inside or outside of work between these employees? Do we know that these employees work together at another employer, and could there be a carryover from a dispute or an issue that occurred there? I think all of us know in the hospitality industry, certainly there's time that there's servers and kitchen staffs who move around a lot. And I can't tell you how many times I've done an investigation where there was a complaint by one employee against the next, and it seemed kind of innocuous at first, right? It didn't really trigger what we would normally expect to be, a workplace harassment type claim. And then in the process of doing it, we discovered that these employees had worked together before for a long time, and they had a very difficult working history. And that played a role into how they interpreted what the one was saying and how they were interacting. And while certainly, what occurred at a prior employer is not going to be your responsibility, it is important to know that, because it's important to evaluate that situation to determine how these employees will be able to work together moving forward, knowing that they may have had a difficult history. So you've developed what your questions are going to be. You've determined what you're going to ask everybody. And now you're going to conduct the interviews. So the first thing you want to do is you want to be calm. Regardless of the nature of the allegation, how severe it is, or how maybe you think that it is not significant, we want to come across as being the calm, the in-charge person in the room. And we always recommend that you begin by letting people know exactly what's happening. And so as far as if it's a victim, the person is accused, you say, hello, I'm here to interview you about your allegation. You want to stress to them that the employer takes these allegations very seriously and is committed to uncovering the truth and taking appropriate action if necessary. If it's the accused, they're going to be very nervous, but you need to be honest with them. And you want to tell them, I'm interviewing you because there was an allegation made that you have done the following. And we have not concluded, we haven't determined that that's true, or that you did anything wrong. But as an employer, we have an obligation to undertake a thorough investigation, which is what we're doing now. And we are going to fully investigate this, and we are going to provide you the opportunity to share all the information that you have. And you want to make sure that you maintain a level of respect. We don't, regardless of somebody's age, maturity, educational history, position that they have in the organization, we want to treat every single person with the utmost respect and have them feel as though they're being respected. If it's the victim, it's important that they feel respected, that the company takes this seriously and is committed to assisting them. If it's the accused, you want them to feel respected and that know that you are acting in a non-biased manner, so that they'll be forthright and that they don't believe that they're being set up or that the cards are stacked against them. And so you want to be, if you're dealing with fact witnesses, they'll be very nervous, right? Because this could be the first time they're ever being questioned about something. And particularly with fact witnesses, it's very critical to tell them, you know, I'm meeting with you because we received a complaint from one employee against another, and you were identified as somebody who may have information about that or who may have been present. And I'm here to talk to you today as a fact witness. I want you to know nobody's accused you of doing anything wrong. And if that's the case, that you're truly meeting with them as a fact witness and there's no allegations of wrongdoing made against them, you want to make that clear to them, because that'll obviously cause them to be much more comfortable in their conversation with you. You want to be professional. Now professional doesn't mean acting like a seasoned police officer, detective, or interrogator. Professional means that you conduct yourself in a professional manner, in a respectful manner, in communicating the allegations, that you don't make jokes about it. You don't say, you give an opinion to a accused, a victim, or a fact witness as to what you think happened. You don't tell people that you think one person's a liar and another's not. You don't say, oh, I can't believe this happens here, these people are crazy. You want to act in as professional a manner, ask your questions, listen to everybody's answer, ask appropriate follow-up questions, and not pass any judgment or give any body language or any signs that you've prejudged what's occurred, or you don't think they're telling the truth, or that you're not interested in being there. And I can tell you, there's sometimes individuals may come across as very nervous, and that may cause you to think they're not being truthful. And I've had that myself, where I've interviewed people and questioned them, and based on their demeanor and the way they spoke and their body language, I had legitimate questions as to their truthfulness. But at the conclusion of the investigation, when I looked at all the information in the totality, I determined that person was actually 100% truthful. But they were just so nervous and so upset at the process that they were exhibiting that body language and those signs that can sometimes be indications of being deceitful. So we don't want to prejudge anybody, witnesses, or accused, or our victims. You want to remind everybody, as we said at the beginning, that this will be confidential to the extent possible. When they say, well, what does that mean? You say, we will only make disclosures if we have to, whether it's to law enforcement, whether it's to a government agency, or if part of our investigation, we have to question individuals, we have to provide specific evidence or examples, we may have to do that. But we're not going to just disclose this to the business at large, to the employees at large. We're not going to go around talking about it. We're going to instruct everybody else not to talk about it. And so you want to remind them of that at the outset of the interview. You also want to remind the employees that your business is committed to a safe and a healthy workplace, and that this is why you're meeting with them, that this is part of the business's commitment to be respectful and responsive to its employees. And that in order to do that, you need the employees' cooperation. You want to have them be invested in this process and tell them that you cannot, as the employer, fully investigate the allegations and make a determination as to what occurred and respond to any poor behavior or fix any issue unless you have the cooperation of the employees and you're fully aware of what took place. And then after you've asked your specific questions, after you've gained a level of comfort with them, after you feel as though it's a conversational exchange, you want to conclude by giving the employee the opportunity to say anything else about this issue. You've asked the who, what, when, where, and how. You've documented if they think that there may be outside evidence that's relevant. You've followed up on their questions. But even if you've done all that, you'll be surprised how many times employees may not disclose something because they're not really sure if it's responsive to what you're asking. And so we always recommend that you conclude these types of investigation interviews by saying, is there anything else that you think might be relevant to this issue, to this allegation, to this dispute? And you tell them it doesn't matter how trivial it is. If it happened at work, if it happened outside of work, if it happened a few weeks ago, a few months ago, is there anything else that you think I should know in order to do my job as best I can? And very often people will provide you with information that's highly relevant, but they didn't view it technically at that time being responsive to your exact question. But when you give them that opportunity to expound on an open-ended manner, they'll share that with you. So you've concluded your interviews. You've interviewed the accused. You've interviewed the victim. You've interviewed the fact witnesses. You've reviewed any text messages, emails, video recordings, social media posts, maybe internal documents, memos, anything that could be related to this dispute or alleged violation. You want to make sure everything's documented, right? So after you interview witnesses, you want to write your own witness summary of your notes as to what the witness told you. You also want to give the witness an opportunity, both the fact witness, the complainant, and the accused, to also fill out a document and write out their version of events in writing, even if you've spoken to them and you've taken down notes. Many times I've seen it where people have written down something that might have more detail than when they're speaking, because when they're speaking, they're nervous. They may have thought they said it and didn't. And so you want to give people the opportunity to document that. And you should have a form for that. It should be a complainant form, and a respondent or accused form, and then a fact witness form. And so as part of your record, you'll have your notes from the interview. You'll have the individual statements. You'll have any evidence such as the text messages, emails, memorandums, security recordings, anything, social media posts along those lines. And then you've got to make a decision. Now, some of these decisions are going to be easier than others. You know, you may have a recording and 5 witnesses that showed that employee A hit employee B right in the face. Other times, you may be provided with a situation where there's conflicting testimony, even conflicting testimony between the fact witnesses themselves. And you'll have to make a determination by weighing those facts. And if it's a very serious issue, you probably want to consult with counsel. But when you reach that conclusion, you want to document it. And you want to have your own internal report, not necessarily something you share with the public, not that you share with the accused, not that you share with the complaining employee, but your own internal document that reflects when you received the complaint, how you responded, what your investigation consisted of, attach all of the documents, and what your conclusions are. And that's important to have from a risk management perspective, because unfortunately, if down the road somebody were to bring a claim of harassment, discrimination, retaliation, you would want to be able to demonstrate that the employer acted in accordance with the law, was prompt, and was diligent in conducting its investigation. Then you also want to, once you reach your conclusion and determine whether it's founded or unfounded, whether a discipline is necessary and the extent of that discipline, you'll want to document that. Obviously, if we're disciplining an employee, we're going to document that discipline, and that could go from a written warning to training to suspension to termination. And to the complaining employee, we'll want to meet with them as well. To a certain extent, we have to respect the confidentiality and the privacy of the other employees, including the one who may be accused of wrongdoing. Now, certainly, if somebody's terminated, the complaining employee will see they're no longer there. But when you conclude an investigation, and let's say you found that there was a violation of policy, you want to tell the employee, I investigated this. I determined that the other employee did violate our policy, and if they were given discipline below termination, you want to tell the employee, and we want you to know that this employee was subject to our discipline policy, and we're going to take steps to remediate this and ensure that these types of actions and behaviors don't occur anymore, and invite them certainly to contact you should they have any further concerns. But you want to demonstrate that you closed the loop with them, that they were involved in the process, and that they're aware as to what happened. And then finally, you want to have your sort of final written summary that documents how you concluded it with the complainant and as well as the accused. And we're going to take all of that. We're going to take the initial complaint. We're going to take the evidence. We're going to take the interview notes. We're going to take any discipline that was issued. And we're going to put it all together, and we're going to keep it in a single file so that it's there if we need it in the future. And now your investigation's concluded. It sounds a lot easier than it is. Certainly can be very tense in the workplace. It is for people who haven't done it before. It can be stressful for the investigator as well as for the accused, as well as the complainant and the witnesses. But that's why it's important that you have a plan in place, you have the forms ready, and that you have the person identified and trained who's going to do this. We live in a very litigious society. Certainly in the state of New Jersey, it is very common for there to be claims arising from workplace disputes between employees, and the employer is the target of that claim because the employer is viewed as having the deep pockets. That's why we must be quickly, thoroughly respond to all complaints, thoroughly investigate it, conclude that investigation, and be able to demonstrate what actions we have taken. Not that will guarantee that you won't be subject to litigation. We can never do that. Unfortunately, anybody can sue anybody for just about anything. But in the event that a claim is brought against you, you will have the opportunity to have this evidence that shows that you acted in accordance with the law. So, of course, as always, we are here. If you need any further assistance on this, please contact me or one of my colleagues, and we can walk you through developing your own investigation policy, development of the forms. We can make recommendations for you on training. We are here to support the NJRHA and its members in all ways possible. And, in the restaurant and hospitality industry, this is an issue that comes up quite often. People are working together in busy, close quarters. There can sometimes be, unfortunately, wrongdoing. Sometimes there's misunderstandings that result in complaints, and we still have to respond as thoroughly to those because we want to diffuse that situation. So having these policies, effectuating these policies will help create a healthier workplace. It'll make your employees feel that you're valuing them and their concerns, and it will help manage your risk for future liability. Again, I'm Brent Pullman with Mandelbaum Barrett, and I look forward to speaking with everybody in the coming months on additional topics. Thank you, and have a great day.